Thank you. First of all, I pay my respect to our visionary leaders who has given us the light to speak on such subject. Today is the 95th year anniversary of Manusmriti Dahan. The subject which we are discussing is directly concerning with Manusmriti. Because this Constitution 103rd Amendment, by which Clause 6 was inserted to Article 15 and Clause 6 was inserted to Article 16, provide for reservation for a class which does not deserve that representation, because they are already represented many fold of their population. This I am not telling only you, I told to the court also. Because at least they are 500 times more represented in the services and in education. The reason for all this is that we do not have a political movement. Ultimately, all these social movements are very good, but when we finally decide to elect decide our fate, we go in the same line. And that decision is the final decision of our fate. So we are deciding against ourselves. But that is a different aspect. I will deal separately that subject. The issue is that a movement which was developed by Bahujans has demanded reservation for Savarnas. Though their population, of course, general perception is 85-15% is the general thinking. But I don't have that type of thinking. I think they are not more than 6 to 7%. The reason is that in 1931, they were about 11%. And they were educated at that time also. And in whole period they are educated. Today we are educated, we have 1 children or 2 children. So they are educated, so they have lesser children. So we were not educated, we have more children. So our population must have increased and their population must not have increased to our ratio. That's why I feel that their population is not to that extent. And this is the reason that they are not conducting caste census. Because they have already conducted caste census in 2011. And they have not released that data. If the data would have been favorable to them, they would have released. When Arun Jaitley, as finance minister, had said in parliament that the data is defective, thereafter the Registrar General of Census Operations, he has given a press interview, said that the data is 98.6% correct. So no data is 100% correct. Even services, you go for reservations and other issues, that data is also not foolproof, because the reserve candidate who has retired 10 years ago, his name will be added, and the person from unreserved category who has just demitted office, his name will be deleted. So the percentage will be different. So this is one parameter. The another parameter is that who can be given the reservation. The reservation can be given to a deprived section who is not in a position to match the competition or the level of the competition or competition playing field, so that they can come forward and they can be selected. Because if you see, prior to Mandal, the reservation percentage was less, but Mandal has crossed, I think, 30 years now. So we can bank upon the 49.5% figure. But when I go to Chhattisgarh, Madhya Pradesh, even there today backward class don't have 27% reservation. Though their population is more than 60% or so, 52%, even Mandal report has assumed that it is 52%, but I feel that that population is more than 60%. But they are not allowing their representation to ensure their representation to the level of 27%, which has been approved by the Supreme Court. So it is the main reason that we are faltering with the system, because our people, maybe scheduled caste, maybe scheduled tribe, maybe backward classes, they feel the God is giving them something. When we were doing that UP case, in the first phase of UP case, nobody from among us was allowed entry in the case. But after 3 years, a news was circulated in the newspaper that there will be revergence. Then some engineers thereafter from UP Power Corporation, they approached and we filed a second petition. So in that second petition, we came to know how they are manipulating the whole game. Because the Bahujan Samaj Party, which was ruling, which was supposed to provide data to the Supreme Court, has not provided data to the Supreme Court, that led to the decision of UP Power Corporation versus Rajesh Kumar, 2011. And still after 10 years, because that was in 2012, 27th April. Now more than 12 years has passed, still we find people who say that the Bahujan Samaj Party has worked very well, they have given this, they have given that. This is unfortunate, because we don't care for our welfare ourselves. That is the main reason that we are suffering. Now come to the EWS. What is EWS? Economically weaker section of society. Who can be the economically weaker section member? A person who is earning 8 lakh in a month. If you see, you all are engineers, how much a assistant engineer is earning in a year? What will be the salary of assistant engineer? Can somebody tell? In a year, it is less than 8 lakh. I think about 6 lakhs or so.
More than 8. More than 8 lakh.
More than 8 lakh. Kitna?
10 lakhs.
10 to 12.
Annually.
I am telling 6 lakh.
10 lakh.
So, a person who is class 1 officer, when it comes to the realization or comparison of a scheduled caste, scheduled tribe or backward class, then you say that he is class 1, his son cannot be given reservation. Of course, SC/ST, that is not applicable, but that is not far off, that is also coming nearby. But for backward class, you are saying a person is class 1 officer, his son or his daughter cannot be given reservation. But when it comes to your own people, then you say 8 lakh is a economically weaker section person. So you have two different criteria for scheduled caste, scheduled tribe and backward classes, and for upper caste. The concern is more about the social conditions of the society. Our social conditions are such that a person who rose to the position of President of India, he is going to a temple. Though as a friend we advise him many times that he should not go to a temple, but still he goes to a temple and he is not allowed entry there. And in one of the temple, he and his wife has went, and there is a criminal case going on. His wife was pushed. धक्का मारने का जो system होता है ना, the pujari pushed her. So in Odisha, a criminal case is going on for that purpose. This is the social condition. A person who has rose to the highest position and is earning maximum in a democracy, he has the maximum salary. But he has no social dignity and he is not equated with a other person as a president. But still they feel that the scheduled caste, scheduled tribe people, they are different and the upper caste are different. If a beggar is there outside your office and that beggar is Brahmin, if somebody goes, he will definitely touch his feet. But if you go in front of a temple and you tell yourself clearly that you are scheduled caste, scheduled tribe or backward class, you will not be treated in that manner. You may be howsoever placed. We have example of president, a chief minister of Uttar Pradesh, a chief minister of Bihar, a deputy prime minister of India. Babu Jagjivan Ram in 1978, when he was deputy prime minister, he went to Banaras to unveil the statue of Sampurnanand. Sampurnanand was a Sanskrit teacher, so his murti was to be unveiled. First, the students had unveiled themselves before he could unveil it. But then they again pasted that ribbon and all those, then he again reopened it. After his unveiling, it was purified. What is the method of purification? Cow dung, गाय का गोबर, गाय का मूत्र, गाय का दूध और गंगा जल. अगर गोबर और मूत्र जो है वो प्योरिटी दे सकता है तो आदमी के टच करने में क्या परेशानी है? But it is only to belittle you. मतलब आपको छोटा दिखाना, नीच दिखाना. For that purpose they are using all these things. This is the reason that the economic criteria theory, which is being developed by a constitutional scheme, is constitutionally unconstitutional. If you see, a theory can be developed. Suppose the Brahmins are facing discrimination. They are not allowed entry in temple or in other public places. There could be a situation which is likely to come in the future. In that situation, you can provide them reservation, because it is only to protect the dignity of a person and to provide him equal opportunities. The equal opportunities cannot be advanced to a person who is already represented. Moreover, because 49.5% representation is there for scheduled caste, scheduled tribe and backward classes. 15% for scheduled caste, 7.5% for scheduled tribe and 27% for backward classes. But when you see, I have already told in Chhattisgarh, Madhya Pradesh, the cases which we are doing, there may be in other states also that this type of system may be there. But they are not providing even 27% reservation to the backward classes. So there is a formula which you have yourself developed, and in that formula you have allowed only 27% representation to backward classes, but you are not giving. So this representation of economically weaker section, which is firstly disproportionate because they are not having that much percentage of population, and that much of percentage of total population, if they are not there, then giving this much of representation without conducting any data or detailed exercise showing that their population is more and whatever is the deprivation and all those aspects and their representation. Moreover, that 49.5% representation which is guaranteed by the constitutional scheme is not yet obtained to that level, because according to the data about 23% or 22% representation is there of SC, ST, OBC all joining together. If you exaggerate some data, still it may not be more than 30%. And you assume that they are already 49.5%, still they are not as per their population. Their ratio of representation is not as per their population. So from that formula, I don't think that there is a justification of providing this reservation to already advanced sections of the society. Then I come to the dissenting judgment. Our Professor Mohan Gopal is normally very happy, and I have seen him saying that we have got two dissent. Basically, that dissent is no dissent. In my perception, that dissent is only to block the representation of the socially and educationally backward classes to the tune of their population. Otherwise, in their judgment, they have said that economic reservation can be provided on the basis of reservation, this economic criteria. If it is permissible on economic criteria, then whether they are 30%, they are 40%, they are 100%, that doesn't matter. Because basically this economic weaker section criteria which is carved out in the constitutional scheme, before that there is no constitutional criteria according to which we can provide reservation on the basis of economic criteria. After this, there already cases are pending in Supreme Court for creamy layer application to SC/ST, and OBC creamy layer is already applied. So you have to see those OBC who comes in the creamy layer category, like say 100 persons are in the merit list who are excluded because of creamy layer, but they are not getting that appointment on the general criteria. Say unreserved slots they are not getting. If you are denying them as reserved category, you cannot deprive them as a unreserved category candidate, because if I am a creamy layer candidate of backward class, it means I am a general category candidate for that purpose. So I should be given a general slot. So no state give them the unreserved category slot. Though as per the constitutional scheme and from Mandal Commission, your R.K. Sabharwal, your Rohtas Bhankar and Vijay Sakla, there are many judgments. No judgment says that you will not give a reserved category candidate an unreserved slot. But at least 8 or 9 states have decided against it. High courts have decided, and in most cases our people they engage, because RSS they are having a network of great value. They hijack everything, and those cases are being filed by their people, and even notice is not being issued in those cases. They are dismissed at that level. Like Rajasthan cases, there the reserved category candidates were having much more marks. About say 30% of seats were to be occupied by the reserved category in this 50% unreserved category slots. But High Court said that they cannot be given, and Supreme Court they filed petition. It was dismissed on the first day, because the petition which you are preparing, that must have some ground. They must have knowledge how they will be getting those positions. And if you engage a RSS men, because mentally they are blocked, they can't study, they can't argue in your favor, so they draft a petition in which you just lost on the first day. So that is the parameter which we are seeing every day. Now we come to the economic criteria, whether the philosophy which we are debating, that economic criteria is not permissible, whether this is constitutionally or as per the jurisprudence allowed, prevalent in the international level, that jurisprudence allow the economic criteria as a criteria. Because in the bench also we have given two articles by Professor Owen M. Fish. This is a professor from Yale University, and he has written one article of 93 pages and another article of I think 47 pages. So two articles he has written where he has explained that recognizing economic criteria as a criteria will defeat the basic purpose of classification. Because if you provide a person some benefit on the basis of his economic standing and don't see his social standing, because the discrimination by economic criteria, the discrimination comes to the society, and if the society is overcoming that criteria, then that discrimination is of no use. Like if a Brahmin is economically weak and that Brahmin is having a public interaction, whether that Brahmin is facing some discrimination, some indignity, means if other person don't feel like he is a human being, like they feel for SC/ST and OBC. So that type of psychology, if it is there against them, then you provide reservation to them. So Professor Fish, for American blacks, he has conducted a research and he has said that economic criteria is a very vague criteria, and such artificial criteria cannot be the basis for determining a constitutional classification. Because for having a constitutional classification, you must have a criteria which have some sound basis. Because I am poor, I don't have 8 lakh income, I applied in this room. I went outside. There I got a message that I have got a lottery or I have got some prize or some other benefit, and now I am earning say 20 lakhs. So I am not in that category. Immediately my category changes. So whether in such a situation you can consider him for a particular specification or a particular classification. So Professor Fish has said this is a artificial criteria. You cannot classify them for this basing any classification. Similarly, Professor Forbath, he is a professor of Austin University. He has also written about 117 or so pages article, and he has also said that the criteria of identification has to be social criteria, because economic criteria, if you are providing a particular benefit, that criteria is very transitory and it changes with time. So once the criteria changes, then you cannot withdraw that benefit. So if you cannot withdraw that benefit, that type of classification, it will not be a constitutional classification. These three articles we have given to the Supreme Court while arguing that case. And that President Ramnath Kovind's example also I have cited, and I have specifically said that a President of India and a laborer, they face the same discrimination. So the social criteria is different and economic criteria is different. If the economic criteria would have been there, then the difference would have been there in their treatment. That difference is not there. So you have to analyze it from a different perspective. Not that we are against economic weaker section, We are not against that. We are debating on a constitutional principle. If a constitutional principle could be evolved whereby a upper caste can be classified as weaker section. Weaker section classification is determinant of many factors because there has to be stigma to that particular class. If you are falling in a particular class, you face a particular stigma, and because of that stigma you are classified in a particular category, and that stigma doesn't pass away so easily that you come out of your room and your class changes. That change is not possible in the social classifications. So social and educational backwardness criteria which our constitution has adopted, Baba Sahib Dr. Ambedkar could labor on those principles and get those rights. And it is basically a Brahminical idea, because you are providing this economic weaker section benefit to a particular class. Whereas 84, the report which was cited, though that report was not the basis of that reservation, but a report was cited in the court. That report says that SC, ST, OBC, they are 84% economically weaker than the other people. The weaker section criteria, the classification, the data which was available. So you can provide a particular reservation, but you have to have a particular understanding of the situation. What will be the impact of that reservation? If you see the way the reservation is being operated in all over India, when the reserved posts are filled up, before your post-based reservation roster application, the vacancy-based roster used to be very better method of giving reservation, because there immediately, if I am not selected in this selection, then in the next selection my post will come, then I can be selected. In this post go to the backlog category, and they don't fill up backlog. So if say 10 posts are not filled up, those 10 posts are backlog posts, they don't fill up those posts. So your representation is affected. So the present system of vacancy based roster, which has rose with the rise of the Mandal Commission and report and judgment, because the Brahminical forces, they are very intelligent, and their commitment is much more as compared to our commitment, I personally feel, because their people, they are doing a lot how to defeat the reservations, how to defeat the reservation of the socially and educationally backward class people. So all these theories, they are propounded. Like this post-based roster, this has no scientific basis, because a post is not filled up. So the post has to be filled up in the next time. But they say that this is a post-based roster. In post-based roster, we find after this economic criteria has come, scheduled caste say 67 posts are advertised. 15% reservation is there. This economic weaker section categories, 96 posts are advertised. They have 10% reservation, but their posts are more in the advertisement. So this is all management in the name of post-based reservation, because they say that their posts are already filled up. So there are no posts for them. This reservation has come only in 2019. So they are giving this reservation from 1997, when the post-based reservation roster was applied. And in railway itself, they have filled up more than lakh of posts. Because one officer was saying that they are filling up posts very hurriedly. And yesterday, this Guwahati, this state of what you call Assam, has notified that we are keeping this reservation for EWS on hold. So even their own government feels that this reservation has some hanky-panky, because that is the BJP government. BJP has only provided this reservation. So they have for the first time put it on hold. And the other states like Chhattisgarh, your other states ruled by other Madhya Pradesh, when the Congress was ruling, they were agitating why they are not providing this EWS reservation. So you have to analyze from all angles. And basically our problem is we have to organize ourselves. Otherwise these rights are not going to be for a longer period, because these rights are fading away, and the people from the scheduled caste, scheduled tribe and backward class categories, their suffering is increasing day by day. Because if you see the kind of deprivation, if you go to IITs, go to AIMS, so many children are committing suicide because of discrimination they are facing there. So many children are committing suicide in the better courses which they are getting admission. And we have to organize the society in a way that some social movement could be developed. And according to my perception, and we have already filed our review petition on behalf of People's Party of India Democratic, and on that behalf only we have filed writ petition. So that writ petition we have argued all those aspects. And secondly, what we have argued, that this Mandal Commission judgment, that Indra Sani judgment, is by 9 judges. And the main judgment is by 6-3. 6 judges are in majority and 3 judges are in minority. But on this economic criteria, almost all judges have opined against this, and one judge, Justice T.K. Thoman, has categorically given a different opinion. The 2 other judges have said something in favor of EWS also and against EWS also. But at least 7 judges have opined or viewed that this economic criteria is constitutionally not permissible, because economic criteria has no basis. And if that judgment is to be reviewed, that judgment is possible to be reviewed by a 11 judge bench. This is a 5 judge bench. Janhit Abhiyan, the main petition was Janhit Abhiyan in that, and our petition was tagged matter. So if you see the way this is going on, the basic criteria which is decided by a court, that is not decided by us. 9 judges, out of 9, 7 judges have taken a categorical view that economic criteria is constitutionally not permissible. So how the 5 judges and can say that economic criteria is valid? Those 2 judges who have given dissenting judgment, they have only said that since it is violating 50% rule, it is not correct. Otherwise, the economic criteria is good enough, you can provide reservation. So I don't feel that that is a dissenting judgment from that angle, because on principle they have not taken a stand. It is a stand so that the reservation promotion may not be increased for the deprived sections. Basically, the society is suffering because of its perception. They doesn't understand how the situation is going on. In this whole social gamut, these people play a different role, and in that philosophy, they have developed that economic criteria is valid, but it is more than 50%, so it is bad. So if it is bad, then how you can say that economic criteria is valid? You have to deal with only a principle, that whether this is permissible or not, it is more than 50%. So whether economic criteria could be there, could not be there, that doesn't survive. But they have divided their opinion in 2 parts, and basically those 2 judges have given a view that economic criteria is constitutionally valid, it could be provided, but since it is crossing 50% limit, so it is not correct. And they have also given a version that you cannot say deny representation to the SC, ST, OBC in this economic weaker section category, because they are also similarly placed. Otherwise, their main basis is on 50%. This is only a passing reference in the judgment. So, if you analyze it from my perspective, I think the judgment is not constitutionally correct, and I hope that Supreme Court will review it. But in the review, because the four judges who are now the sitting judges and the fifth judge who has retired, he has not given express opinion. He has only signed with the dissenting judge. So the other three judges, they have given separate judgment. So these separate judgments, three judges who have given, they are still there. One more judge will be joining them, and on 2nd January, we have got a notice that it is going to be listed. 2nd January is the reopening day of Supreme Court, so we will be knowing what is happening. But I am not very hopeful. I still feel that in a curative petition, perhaps the bench will change, because 3 more judges will be added. Suppose first 3 judges is not joining this review petition bench, then the first 3 judges will also be there in that. Senior most 3 judges, they plus the bench who is deciding this. So if they are deciding, then there will be a different bench. So there perhaps situation may change, but in the review judgment I don't see any major change, because all have expressly delivered their judgments. So there is very little possibility of a change. So we have to wait for another round of litigation in the curative petition. That is my understanding of the situation. With this, I think that we should educate our people, because most of the people think that these rights which we are getting without any reason. And there was a promotion from some department, I don't want to name that department. A reserve candidate crossed say 30 unreserved category candidates. So these people came to them, then that she was a lady incidentally, then that lady went to the officer कि मैं नहीं चाहती हूँ मेरा promotion होना चाहिए. So this type of mindset should not be there. You are not getting reservation in promotion because of their concession, because you are not represented in those positions. That's why you are getting reservation in promotion. So you should stand by the constitutional scheme. Most of our people, I personally feel, are not standing to the constitutional scheme also, because whenever the situation comes, they are not committal to the constitutional principles. That is also my concern, because ultimately Baba Sahib Dr. Ambedkar, because of his education, he could give us all these rights. Otherwise, I don't think you would have been getting any of these rights. In America, they got the voting right in 1965. You got in 1950. So 15 years before them you got these rights. And still our people, they don't feel that they should stand with those principles. And it is very difficult to translate in such a way that these rights can be sustained only by your continued efforts. If you are not continuously making efforts, then these rights are not for very long period. And they are trying to bifurcate you. There are petitions pending. They want to bifurcate scheduled caste in ABCD category. In addition, they want creamy layer application. So they want to apply creamy layer to scheduled caste, scheduled tribe. Already OBC it is there. Though in all cases we say that it should not be applicable to OBC because they are also facing social discrimination. And with their economic condition, their social discrimination doesn't fade away. That still continue there. So we feel that that economic criteria should not be the basis for scheduled caste, scheduled tribe and backward classes. And this economic reservation, I hope that it will not stand for a long, because this is not on a constitutional principle. Though they have incorporated a provision in the constitution, but that provision is against the constitutional scheme and constitutional jurisprudence. Internationally, whatever the jurisprudence we are having, none of the cases support this type of idea. So we have to stand up and organize ourselves. Only then we could protect our rights. With this, I think I have taken longer time. Thank you. Jai Bhim, Jai Bharat, Jai Mool Nivasi.